Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. In this video, I want to discuss with you something known as AB 1950. AB for Assembly Bill 1950, passed in California in the latter part of 2020, going into effect on January 1st of 2021. And what AB 1950 affects is the length of probation for those people who are convicted of a crime, whether a misdemeanor or a felony. So I want to break down what AB 1950 really is and what it doesn't, and how it could affect you and how it could actually help shorten your period of probation, and how you and your attorney should be able to use that to your advantage moving forward, whether you're convicted of a crime in 2019, 1989, whatever the case may be, or whether your case is currently being litigated in court, how you could possibly use that to your advantage. So let's talk about it for a little bit. AB 1950 talks about misdemeanors and felonies. Misdemeanor probation, with the exception of a few, one notably being a DUI, where you could get up to 5 years probation. Misdemeanors, for the most part, have a cap of 3 years probation. AB 1950 drops that ceiling all the way down to 1 year maximum period of probation for most misdemeanors. Still doesn't affect a DUI. You can still be on probation for up to 5 years on a DUI. And it doesn't affect most, if not all, domestic violence misdemeanors, where you could still be on probation for up to 3 years. But most misdemeanors, effective January 2021, you're dealing with a year max. That'll help as far as, obviously not being on probation, but quite frankly, the terms of probation, summary misdemeanor probation, there's really not a whole lot you need to do other than complete your sentence, pay your fines, do your classes, whatever you need to do. But why it's really important is once you're off probation, you're then eligible in most instances to have your conviction set aside and dismissed under Penal Code Section 1203.4, which is known as expungement. So real significant advantage there coming up. You and your attorney should be looking ahead. If you have a case going on end of 2020, make sure you're negotiating for shorter periods of probation, or at the very least, it might behoove you to put sentencing into 2021 to take advantage of this new law. Now, as far as felonies go, what we're hearing and what we've read is that felonies are going to be dropped from 3 years and more in many instances down to 2. Okay, and there are still going to be some offenses where you could get pretty much up to the maximum you could get in prison on probation. There are some other violent felonies, strike felonies, where you're still looking at probation probably around 3 years or so if you're convicted and don't go to prison. But a lot of felonies will be reduced to 2 years. Another exception actually would be grand theft by employee or embezzlement when you're dealing with more than $25,000. But again, similar to the rule with the misdemeanors, by dropping that probation to 2 years, what that does is it makes people eligible for expungement faster, assuming they successfully complete probation. Now, why is California doing this, right? Well, California is actually ahead of it as far as listening to evidence-based practices on what really works and what doesn't. For the longest time, it's, 3 years, 5 years. No matter what the case, no matter what the offender, no matter what the situation, and then you have to go into court after 18 months, 24 months, and try and terminate probation early, right? California's actually looked at this and they said, wait a minute, what are the studies showing here? Well, the studies are showing that for the most part, the most effective probation are for the first 18 to 24 months, right? The first year and a half to 2 years. And that's important on felonies. On misdemeanors, you're really not having any supervision at all, depending on the offense. Most misdemeanors, you're on probation to the court. Stay out of trouble. No one hears from you again as long as you do what you're supposed to do. Felony probation, people getting released from jail really need the services that probation should be able to provide. People who, have had their world upside down in large part through their own decision making, which landed them in the criminal justice system. Obviously there's a lot of exceptions to that. But, these are the people who need probation. These are the people that need the supervision. And what I can tell you is being a criminal defense attorney in San Diego, coming up on 14, 15 years, what we're dealing with is a lot of times the first year or so there's intensive levels of supervision and not a whole lot afterwards anyway. So this is actually being proactive in terminating probation or shortening the period of probation. Now on the other side of the argument, people who are against this are like, well, the court could, set your probation for a year or 2 years, and they're against this sort of, one size fits all. You get 1 year for a misdemeanor, 2 year for a misdemeanor, or 1 year for a felony. Excuse me, 1 year for a misdemeanor, 2 years for a felony. So we get that. We understand that's the argument, and the reality is the court could always have done that. The problem is the courts haven't done that, and they've been quick to rubber stamp the 3 years probation, 3 years probation, without really looking at individual offenders and what really the evidence-based practices are showing them and showing us. So keep an eye out for AB 1950. Utilize it to your advantage. Get your probation shortened if you're on probation now. Use it as a negotiating tool in your criminal case if you have one pending. And even if you have a really old conviction, just that whole mindset shifting as far as evidence-based practices, what works, what doesn't. You might be able to use the spirit of the law behind your petition, whether it's to reduce it to a misdemeanor, your felony to a misdemeanor, whatever the case may be. If you have any questions about AB 1950 or anything related to California sentencing, feel free to give my firm a call, 619-295-3555.